Reprise du débat, continuing debate. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Mr. Speaker, and I'd like to first off acknowledge I'm speaking to you from the traditional lands of the Algonquin people, and I also want to acknowledge the work of my friend from St. Albert, Edmonton, for his persistence in bringing forward Bill S-206, an act to amend the Criminal Code, disclosure of information by jurors. The amendment proposed by Bill S-206 would permit jurors to discuss jury deliberations with healthcare professionals following the trial in order to address health issues that have arisen as a result of their jury duties. It would do so by adding an exception to the offense of disclosure of jury proceedings under Section 649 of the Criminal Code. I'm pleased to say that the government will be supporting this bill. Bill S-206 is nearly identical to former bills introduced in previous parliamentary sessions, notably former Bill C-417, which the government also supported. Bill S-206 includes a change to the Criminal Code that has garnered unanimous support, and I believe that it should once again receive the same treatment as it is a worthy objective. I want to thank Mark Ferrand and the Canadian Juries Commission for their tireless advocacy on this bill, and on behalf of Canadians who have served on juries across Canada. I greatly appreciate the opportunity this bill provides to consider the important civic duty of jurors, including the pivotal role they play in the criminal justice system. I would also like to speak about the purpose of Section 649 of the Criminal Code and what effect the amendments proposed in Bill S-206 are expected to have. Juries are critical in their contributions to the justice system in Canada, and they have an important role in upholding our Constitution. The Canadian Charter of Rights and Freedoms guarantees the right to a jury trial for offences carrying a maximum penalty of imprisonment of 5 years or more. The Charter also guarantees guarantees a right to a trial before an independent and impartial tribunal. Under the Criminal Code, certain criminal offences provide for a presumption that the accused will be tried by a judge and jury, for example, murder. And for other offences, an accused can elect to be tried by a judge alone or jury and judge, for example, sexual assault and robbery. In a trial involving a judge and jury, jurors act as the triers of fact and replace the judge in this role. The right to a jury trial is not a constitutional one, but one in the civil context. The right to demand a civil jury trial is a statutory right that is limited to certain circumstances found in provincial and territorial legislation. However, in some jurisdictions, juries are not available at all for civic cases, for example, in Quebec. Canada also has juries in the context of coroner's inquest, whose important role can involve making recommendations in relation to the death of an individual. The Supreme Court of Canada, in R.V. Davey, held that the jury, and I quote, reflects the common sense, the values, and the conscience of the community. The jury has also been described by the Supreme Court as, and I quote, an excellent fact finder and a final bulwark against oppressive laws or their enforcement, which increases societal trust in the justice system as well as public knowledge of the criminal justice system. And in R.V. Sherrod, moreover, the Supreme Court stated in R.V. Find that trial by jury is a cornerstone of Canadian criminal law. It offers a citizen the right to be tried by an impartial panel of peers and imposes on those peers the task of judging fairly and impartially. These statements and observations by our highest court inform us of the great value placed on juries in Canada and the individuals who make up a jury, with notable references to the significance of juries in the criminal justice system. The provinces and territories are responsible for the administration of justice, and their legislatures enact laws relating to the establishment of juries for civil, criminal, and other proceedings such as coroner's inquests. Provincial and territorial legislation also provide the basis for identifying potential jurors from the community, determining who may meet the criteria to act as jurors and summoning jurors to court, among other things. With respect to matters within federal jurisdiction, federal responsibility over the criminal law includes the Criminal Code's procedural rules regulating jury trials and the jury selection process that takes place in the courtroom. This includes the requirement that 12 jurors be selected, in addition to one or two alternatives at the discretion of the judge. The challenges for cause, process, and the trial's judge's power to excuse or stand aside prospective jurors provide mechanisms for removing prospective jurors whose impartiality may be in question. The federal government also has a responsibility for enacting criminal offenses and penalties, such as those set out in the Criminal Code. The common law has long provided for a secrecy rule, which excludes the evidence of a juror that reveals statements or opinions made during jury deliberations. Section 649 of the Criminal Code is a codification of this rule. It was enacted in 1972 and provides for a summary conviction offense that criminalizes the disclosure of information obtained during jury deliberations that was not otherwise disclosed in open court. The offense applies to every juror and every person that provides technical, personal, interpretive, or other support services to a juror with a physical disability. The offense is currently punishable by a maximum penalty of imprisonment to 2 years less a day and or a fine not exceeding $5,000. There are no known or reported convictions pursuant to this offense. There are existing exceptions under Section 649 which permit disclosure of information relating to the proceedings of the jury. These are in respect of an investigation or prosecution of a charge of obstruction of justice in relation to a juror under subsection 139, sub 2 of the Criminal Code. The common law jury secrecy rule and offense in Section 649 serve the purposes of promoting free and frank debate among jurors, protecting them from harassment, and maintaining public confidence in the administration of justice, as well as helping preserve the constitutionally mandated integrity of the jury system. However, Section 649 has been identified as a barrier to jurors seeking mental health support. We heard in the course of testimony before the House of Commons Standing Committee on Justice and Human Rights during its study and its report named Improving Support for Jurors in Canada, May 2018, that jury duty for some individuals has involved significant personal sacrifices, stresses, and strains, with some former jurors experiencing post-traumatic stress disorder or other mental health trauma. Former jurors have reportedly encountered resistance from mental health professionals in serving them because of Section 649 of the Criminal Code. This is very concerning, as individual jurors that make up a jury are invaluable to our justice system, and the difficulties they encounter must be recognized and acknowledged. The narrow exception being proposed in Bill S-206 is meant to make it easier, clearer for jurors to get mental health treatment for issues relating to their service and be able to disclose information about what went on during jury deliberations that may have impacted them. For example, they will be permitted to disclose information beyond that was disclosed in open court, such as graphic photos or disturbing testimony, and to discuss it with a healthcare professional, other aspects of the trial, and jury duty which may have affected them, such as the weight of the decision they've had to make. Finally, Mr. Speaker, the bill includes a coming into force period of 90 days after the bill receives royal assent. This would allow the provinces and territories some time to effectively implement the change to Section 649, given their primary responsibility over the administration of justice and jury trials, as well as the juror supports generally. This seems to be something that will be welcomed as an improvement for jurors involved in the criminal justice system who, as previously described, may face the need for mental health support following a trial, and this help should be accessible, Mr. Speaker. I hope that all members of this House will join us in supporting Bill S-206. Thank you.